That way it just becomes a thing we can have available.
Yes, absolutely.
Which is lovely.
Oh, look at us. We're getting some last minute 1, 2, 3 people registered in the past 5 minutes.
Yay! We got the procrastinators. I love it.
Okay. Are you just in audio? You're not going to pop on the screen all of a sudden, are you?
It says you stopped it. So.
It says I stopped it?
Yeah. You cannot start your video because the host has stopped it.
What does that mean?
I don't know.
Do I have to go into the settings? Wait, can I? Hold on.
I was going to pop it on and then pop it off. But
mute audio, chat, make host. Make Erica Berry the meeting host. I don't know that I want to do that.
I don't know if you want to do that.
Change role to attendee, forbid record, remove, rename, put on hold. Why can't I? Do you have your video turned on?
When I go to start video, it says you can't start because the host has stopped it.
It's just so ridiculous. Of course this happens right now. Of course. Hold on.
Sure.
Who can share? All panelists. Who can start sharing? All panelists. How about now?
Let me see. Not yet. Let's see.
More. No. Video settings. This is going to be a Zoom thing, isn't it? It just never fails. I've done this before. What was going on? Let me go to Zoom real quick. My account, webinars, this one, edit. Okay, try now.
I just did touch up my appearance, so maybe that'll make things better too. No, not yet.
I'm gonna pop. Well, no, it's not. It's now. It's 8:02. I'm just gonna go live.
That's fine.
Good evening.
Good evening. All right. My name is Erica Berry. I am the disembodied voice you hear. I'm the executive director of the Onondaga County Medical Society. Welcome to everyone who's joining us this evening. I want to thank the Marrone Law Firm for doing this for our physician members and for all of our other local medical professionals. The Medical Society at both the local and state level is committed to advocating for our members and supporting them so they have the resources needed to be successful and to practice quality medicine. We had been hearing about how coronavirus was causing people to reassess what they did or did not have in place and whether their plans were current or updated. So I'm very grateful to Anthony for offering up his services and expertise in this difficult time. He's a real asset to our community and just exactly the person you want working with you and your family. We hope that this webinar and the services that Anthony will be talking about helps provide some peace of mind. Please continue to reach out to the Medical Society with your needs and experiences and let us know how we can help. All right. Thank you, Anthony, for trying this evening hour with us. Yes. I know you are balancing a few things as well.
Yeah. Good evening, everybody. Thanks, Erica, for having me. My name is Anthony Marrone. I'm an attorney in Syracuse, New York. I own the Marrone Law Firm, which is located downtown. I'm coming to you live tonight from my home office because lawyers have been deemed non-essential, unlike doctors. So we have been working remotely for the past 6 weeks now. And I just want to give a shout out and say thanks to all of you who are still going to work and plugging away. Really appreciate everything that all the medical professionals have done. We've got some special offers, some free stuff for you guys at the end. So make sure you stick around to the end. Without further ado, let's get started. So if you have any questions along the way, if you're on the Zoom platform, you can either leave them in the chat window, or there is this great little Q&A feature at the bottom of your screen where I will come back at the end and try to answer any questions you have. And you can ask the questions either using your name or anonymously. So don't feel like you have to sign your name to a question. Tonight, I wanted to cover estate planning during the coronavirus crisis, what everyone needs to be doing now. Obviously, this is a challenging time for the entire world, specifically those of you in the medical industry. And we are sensitive to that as estate planning attorneys. So we've got some tips and tricks and best practices lined up to kind of guide you through this difficult time. If you don't have any legal planning in place, I'm going to provide you with the information and tools that you need to get a plan in place very shortly. The one thing to keep in mind about what we're going to be covering, especially if you have specific questions that are personal to you, you can always feel free to email me. I'm going to have my email address up at the end of the webinar. You'll be getting an email from me with copies of these slides as well. So don't feel like you have to take copious notes. Feel free to email me anytime with any questions you have. I'm happy to help out, especially during this difficult time. So tonight we want to cover a few topics. I'm going to try to get through everything quickly. I know everybody's busy and tired, and if you're like me, you've still got the kids to put to bed. So we're going to cover the 3 basic planning documents that everyone needs. We'll talk about some of our virtual planning options, especially with some of the changes in the laws that the governor has passed in the past few weeks. We've got some very interesting flexibility and new opportunities to accommodate physicians and medical professionals and help get these documents signed, even though we know you're running very short in time. We're going to talk about a new topic, standby guardian for healthcare professionals. So for those of you with minor children still, like me, if you're a healthcare professional, there's some new provisions in the law for you. And then we'll wrap up with our offer in conclusion, which is going to be some free planning for doctors and medical professionals. So first, I've done probably more of these Zoom webinars in the past 4 weeks than I did my entire life before that. I very much prefer to be with people giving these types of presentations in the presence of a live audience, but this will have to do. So I've been using this intention, setting this intention at the beginning of every webcast that I've done. And I think it's particularly apt if you're working in the medical field right now. We know that what we're going through both locally here in central New York and nationally and globally is just terrible. There's not really any way around that description. We were largely caught unprepared as a people for this type of pandemic, despite ample warnings from medical communities. And I think it's important to keep in mind that every storm runs out of rain, and we can't predict necessarily the end point for this. I just think it's helpful for me to stay grounded in the fact that this won't last forever. And with that in place, I want to talk about the 3 planning documents that everyone needs. So many of you will be familiar with the first document, and we're specifically referring to healthcare proxy. You'll see on my screen. So healthcare proxy, for those who don't know or maybe are not familiar with this document, is where you appoint someone to make medical decisions for you if you cannot make them for yourself. So if you're unable to make those healthcare decisions, you're unable to speak for yourself, you're unable to communicate, you're appointing what's called an agent to make those decisions for you. Additionally, there's a lot of talk about what's called a legal will in New York State, or a living will in New York State. And I just want to dispel, I always get questions about the differences between a living will and a healthcare proxy. It's important to note that under New York's public health law, the living will is not a separate legally recognized document. So the public health law provides for the creation of a healthcare proxy where you're appointing someone to manage your affairs, but it does not provide for living will. So what we do in our practice when we're utilizing this tool is we roll the living will language, so end of life palliative care language, into the healthcare proxy document. So what that does for practical purposes is gives us an opportunity to tell you what exactly we want from an end of life perspective within a document that's going to be legally recognized in the state of New York. So within a document that if I needed to take it to court to have it upheld, I could do that. And that's why, at least in my practice, we specifically utilize the healthcare proxy with living will language for purposes of, for purposes of establishing someone's intentions about end of life. We also authorize HIPAA disclosure within that document and indicate whether or not you want to be an organ donor. So many medical professionals, I'd say most medical professionals, are going to be familiar with that document. That's step one. The next phase, the next document that you really need, desperately need, is a power of attorney. And you may be familiar with this as well. A power of attorney appoints someone to make financial decisions for you if you are unable to speak for yourself. So if you're unable to pay your bills, if you're unable to handle your taxes, whether you're disabled or elderly and suffering from cognitive decline, you would be appointing someone to make these decisions for you. I'll give you an example of how this is specifically important. I've had a lot of clients that have suffered stroke or heart attack or some kind of debilitating condition with a very rapid onset. And so many of them have utilized or were utilizing their 401k or IRA to subsidize the cost of their living. So they're using their retirement money to pay for things in retirement. Well, the problem is if you are disabled or some kind of incapacitated in some way, and you don't have a power of attorney, even if you're married and your spouse is the beneficiary on one of those accounts, your spouse will not be able to legally access that 401k or IRA. And this also applies if you have other bank accounts or investment accounts that are in your name alone. Without a power of attorney signed and valid, your spouse or significant other or child, whomever you've named, won't be able to access those documents for you or won't be able to access those assets for you. So power of attorney, I've always said, can become the most important document that you sign, because without it, there's an entirely separate, complicated, expensive process that we have to go through to get access to your funds. So especially if you're interested in continuity of access to money, particularly if you're married, I think the power of attorney takes on paramount importance for people. There's a lot of other options that are kind of nestled within the power of attorney that we go through when we prepare these documents. You'll have some leeway to give this person that you're appointing permission based on what your comfort level is. You'll be able to dictate whether or not they should be paid for their work. Additionally, you'll be able to decide whether they should be able to make gifts of your assets. So if you're not inclined to give them that power, you don't have to. Last and probably most common when we are talking about estate planning with folks is the last will and testament. And I put here, you could see will or trust, because it could be both. And essentially, when I'm explaining this to people, I explain it the same way to my 6-year-old son that I explain it to a 96-year-old client. You essentially want this document to do two main things. Step one is figure out who gets your stuff, boiling it down very plain and simple. Who's going to get everything? It can get incredibly more complicated as we layer on different plans and different instructions that you have. But at its core, part one is who gets your stuff, and part two is who is going to be in charge of making that distribution or those distributions. So whether it's a last will and testament or some kind of trust, and we'll talk about that in a minute, at its very boiling it down to its very simplest steps, you're looking to accomplish two things. Who's going to get my stuff? Who's going to be in charge of it? There's obviously more complicating plans that we layer on top of that, especially if you have any kind of tax concerns, or you have a disabled beneficiary, or you're worried about children or grandchildren being minors. There's additional protections that we build into that document, but just from a conceptual perspective, at its very basic, the will or trust is accomplishing those few things. Okay, just to circle back and make some additional points on these three documents. So now you know those are the last will and testament, the power of attorney, and the healthcare proxy are the core of what I consider to be estate planning. So you'll often hear the term estate planning, and many people say to me, well, I have modest amount of wealth. I don't have an estate to plan. And the simple reality is that if you own anything legally in New York, you technically have an estate. You may not have an estate that's the size of Bill Gates, but you have an estate. So when we say estate planning, really what that's code for, what that's jargon for, is a last will and testament, a healthcare proxy, and a power of attorney, and potentially a trust. On the power of attorney, there's a few additional points I wanted to make. So it's a very important document, as we've discussed. It's one of the most important. One of the reasons that it's especially important and can be incredibly powerful is that it is effective immediately. So once that power of attorney is signed by you and by the person that you've appointed to be your agent, the person you've picked to manage your affairs, that document is effective. So there's no specific waiting period before that document takes full effect. Now that could be very good, especially if you have an immediate need. It can also be somewhat challenging depending on the family dynamic and who you've appointed. One little strategy that we'll use, especially for clients who don't want it to be effective immediately, is I'll have the client sign it, all right? I'll have my client sign the power of attorney, and then we will hold it in our safe until that's needed by the family. And that allows us to do a little investigative fact checking and make sure that the document's really going to be used for appropriate purposes at the time. So you want to choose someone that you trust implicitly because you're giving them a lot of authority over your finances. And this is just an area, I said it's the most important document. That's both good and bad. It can be the most important document because you're giving someone a lot of authority, and that's great because it helps with continuity of paying your bills and managing your finances. The flip side of that coin, especially as we see with a lot of folks suffering cognitive decline, Alzheimer's, dementia, and other afflictions like that, what we notice is there's a lot of potential abuse. So I serve on in 7 different counties across central New York. Vera House, which traditionally does domestic violence, also does elder abuse and elder exploitation. And I serve as the attorney on all of those committees across central New York. And for sure, one of the biggest areas that we see is abuse by someone as power of attorney. So they've become power of attorney and had good intentions, may have started out fine, and then they are taking advantage of the individual. So you want it to be someone you trust implicitly, and we have to be cautious because this is an area where, especially if you're appointing someone who's not financially savvy, this is an area that can lead to a lot of potential abuse. Next up is the last will and testament. And this is, again, where you're going to say who gets my stuff and how we split it up. This only takes effect after you pass away. That's a very common misconception. So the last will and testament will take effect after you die, after a death certificate has been received. And then there's a court process known as probate where the will gets proven to be valid. If you have little kids, so if you have children who are under the age of 18, the last will and testament takes on a special importance because it's the only place that you can designate someone who will be guardian if both you and the other parent, the other biological parent, are deceased. So in the event that both parents pass away, both natural guardians pass away, the last will and testament is the only document that you can use to designate a guardian. So in my world, for parents that I'm dealing with and in my own personal life, having 3 kids who are all under the age of 9, that takes on a huge significance to me and to my clients, because having that plan in place, having those people lined up for my children or your children, when hopefully never that time comes, but if that time comes, is the most important thing you can do from a legal perspective when you have little kids. Power of attorney, most important document as you get older, I think. Last will and testament, as long as you have kids that are under 18, to me, that's the most important document. Coincidentally, it's also the specific to the guardianship issue. That's also the area where we have the biggest amount of disagreement among spouses. So that takes sometimes some negotiation, sometimes by me, sometimes between the spouses, to kind of navigate those waters if there's a disagreement about who should be the guardian. So if you have little kids or a family with little kids, that's something to keep in mind. Another thing, another common misconception, common trap, is the last will and testament is only going to direct transfer of assets that are in your name alone when you die. So an example of this is if I have a life insurance policy and my life insurance policy names my mother as the beneficiary, but my will says I give everything to my wife. Well, the life insurance policy beneficiary designation is actually going to supersede what it says in my will. So if I have something that's set by beneficiary designation or joint ownership, that's actually going to supersede what you put in the will. So it's something to be cautious of. Coordinating all of that when we sit down to do a plan with a client is important, because we want to make sure that we're directing the assets where they actually want them to go and not just ignoring any beneficiary designations they may have made. One other point as an addition to a will is, especially for a lot of physician clients, we look at using a trust, which is a substitute for a last will and testament, to receive ownership of some of their assets. So particularly if you're in a practice that has a high degree of malpractice litigation. The good news is I'm not that kind of lawyer. The bad news is we've got to do something to protect those assets. So we use an irrevocable trust, very common planning tool for doctors and medical personnel to insulate themselves from liability. So properly structured, that's going to provide you with really good creditor protection. In addition to good malpractice insurance, which all of us professionals have to have, the properly structured irrevocable trust will provide you as much asset protection as you want. Additionally, an irrevocable trust provides a really good vehicle for sheltering your assets when you retire from the cost of long-term care. So doing that kind of planning typically needs to be done 5 years or more before there is a need for long-term care, but that's really popular among a lot of my clients to shelter assets, potentially insulate those assets from the cost of long-term care. Additionally, a trust can be a really great way to avoid probate costs. So we talked when you pass away, the last will and testament has to be probated. Using a trust that's properly structured and properly funded will avoid all of that probate cost. So it's really good vehicle to minimize your post-death administrative costs, at least. I want to talk for a second about our new virtual planning. I said this to my wife. She said it sounds like it's from outer space or galactic. Very simply, Governor Cuomo has now authorized us to do some things to help people get documents prepared and signed that we've never been able to do. So while you may have used a tool like DocuSign to sign, I used it when we bought our house. I never actually signed anything on physical paper. For as long as we've had things like a last will and testament, power of attorney, healthcare proxy, they've always had to be signed in the presence of a person. So a physical, what we call a wet signature. What's now been authorized in the wake of the coronavirus pandemic is a signing to be conducted much like this. So I can be in my home office. I can have two witnesses from my team, from my staff, who are also at their remote locations, and we can tap into whether it's Skype, Zoom, FaceTime, any of the video platforms that are available, and walk you through signing your documents without being physically present. And that's now, at least for the next month, temporarily authorized in the state of New York. So we've been able to utilize that to get all kinds of our estate planning documents and clients signed, sealed, and delivered without ever having to violate any of the social distancing protocol. So, especially because lawyers are deemed non-essential, hurts a lot of lawyers' feelings to hear that, I know. Probably makes most doctors happy, but the lawyers being deemed non-essential, we've had to get creative with how we get these documents signed because there's been a big demand. People are nervous and people have more time on their hands by and large that are not working. And so we've had to be creative, and the governor has now allowed us to do this. Additionally, if you take us up on our free offer that we'll talk about at the end of the program, you'll be utilizing our portal, which is called the Will Builder, which we've designed to be virtual. So you'll be able to answer some questions from the confines of your own home on a computer or an iPad or a phone, if you use the phone like me, and then you'll meet with me virtually, just like this, face-to-face, or we can have a phone call, and we would draft everything, customize it to your liking, and then sign it just like this virtually. So kind of fancy. A lot of lawyers aren't necessarily caught up with this technology, don't love it, but it allows us to get documents signed and stay safe. And particularly if you're just working, I know a lot of my friends who work in hospitals are just working crazy hours right now, and we're so appreciative of that. We'll talk about our offer at the end, but this allows us the flexibility to get documents signed. I know personally, having represented a lot of doctors for a number of years, I've historically done some will signings in crazy places, like outside of the OR. Don't tell any of the administrators, I guess, in the waiting rooms of physicians' offices and in their offices in between seeing patients. But now we have the additional flexibility to do virtual signings. And I've got flexibility where we can do it night times, weekends. If you have unorthodox hours, we can make that work as well. One more thing I wanted to kind of talk about before we move on to the what we're going to offer healthcare professionals. There is a new provision. Well, we've always had the ability to designate a standby guardian in certain circumstances if you have minor children. So if you have minor children and you were going to be traveling or you were going in for some kind of procedure, there's been the ability in the New York State law to designate someone to be guardian if something happens to you. Now that pool of circumstances where you could sign a document like this has been expanded to healthcare professionals during the coronavirus pandemic. So regardless of whether you're sick or anything like that, you can now sign one of these documents, which provides a little bit of a cushion before the will if you're living but somehow disabled. So God forbid something happens, you're working in response to this pandemic and you get sick. This would allow you to, in advance, have designated someone to provide temporary care for your kids. Really important, has to be signed and witnessed, just like a healthcare proxy. Just wanted to bring that up if you have young kids or physicians or medical professionals that have young kids. So without further ado, let's talk about well, I know a lot of folks are tuning in tonight. As a thank you, in our own little way of saying thank you to healthcare professionals for everything that you have done and continue to do and will do. We wanted to, let me get out of the way here. You want to be able to see this. In a way that we could help make some kind of offering to you guys. So what we've done, and we're going to run it at least through May and probably a little bit longer, is healthcare professionals are going to be eligible for a free healthcare proxy, a free power of attorney, free what we're calling basic documents like that standby guardian form. There's some other, like we'd help you do beneficiary designation forms. In addition to that, we've greatly reduced the price of last will and testaments and trusts. Can't do that totally for free, but we're throwing everything else in for free, and we've chopped our prices on wills and trusts for doctors and healthcare professionals. If you're interested, I'm going to send a link probably tomorrow, but you can also go to www.themarronelawfirm.com/medical. That's www.themarronelawfirm.com/medical. And so thank you for all that you've done and all that you continue to do. At least speaking for myself and all of my staff and team, I know we really appreciate it. If you have any questions and answers, if you have any questions rather, feel free to pop them into the Q&A. I am going to send a link to the recording of this webinar if you're interested. If you have additional questions or comments, you can always email me, Anthony@themarronelawfirm.com. I see a question in the chat. If you share custody of a minor child with an ex, can you influence who takes care of your child if you were to die? Can you make sure that another relative or grandparent splits custody or has visitation rights? That's a great question. So it gets really complicated when there are divorces or custody arrangements in place with an ex. So one of the things that we always do when we're doing planning and we know that someone's either divorced or they have a minor child and we're not married is I want to see a copy of the agreement. So whatever custody arrangement they have that's been reduced to writing, I need to see that. And it just really depends on how that document is written. So there are a lot of occasions where we can actually influence things like grandparents' visitation rights or some kind of joint physical custody through your will, through addressing that in the will. Unfortunately, the law says that when you have two parents and one dies, the remaining parent biologically becomes the sole natural guardian. So what we're usually looking to do in this scenario, and it is tricky, but we're usually looking to write your will in a way to enforce some kind of custody. It's ultimately subject to family court. I know people don't love to hear that, especially people that have been through it, but it is subject to the family court judge making a determination. Now, I've had some cases where one parent has lost custody rights completely, and there you'd probably have a stronger case to be made for, if I pass away, I get to pick the next guardian. But it is something that we tend to handle on a case-by-case basis. How much does estate planning cost? So that's a great question. If you, and I'm going to have a link to this in the material. So I can't publicize. One of the kind of crazy rules on lawyers, I guess it's only crazy depending on who you ask, is that if I were to say the price, it could be seen as price fixing, that I was attempting to fix the price in the market. So if you email me, I will gladly be transparent and show you the fixed fee cost for healthcare professionals. I think we've made it really affordable, definitely more affordable than, or definitely cheaper than what we're usually charging during this time period. And no matter what, you're under no obligation to do the will or trust. So if you just need a healthcare proxy or power of attorney or both, you're always going to get those completely free for me during this offer. Does student loan debt get passed on to survivors? Is there a way to protect families from continuing to have to pay for medical school loans if that person is no longer able to earn income? It's a great question. The answer is yes, there is a way. So what we typically do when we're trying to, I won't say evade because I'm recording this webinar, but when we're trying to plan around significant debt, whether it's student loan debt, potential creditors from a lawsuit, or any other kind of debt, one of the tools that we use is we're looking at how do you own your assets, especially if you're married. And if feasible, we try to shift as many assets that a student loan company or a creditor could grab, try to shift those out of the borrower's name. So if I have, for example, an investment account and it's joint with me and my wife, but we're worried that if I pass away, that investment account is going to be subject to my professional student loan debt, then one tool that we use is to get that asset out of my name. And whether that's through just putting it in my spouse's name or putting it in some kind of irrevocable trust to avoid creditors if I pass away, those are the kind of planning strategies that we're using to kind of do a little bit of maneuvering through that minefield. As a general rule, your estate is subject to creditors. So if I die and there's assets in my name alone, and I have debt, whether it's credit card debt, mortgage debt, student loan debt, my assets that are in my name alone are going to need to be used to pay that debt. So this is why especially for medical professionals, we want to take a very close look at how you own assets. We don't want things like your house or an investment account or a savings account if you're stockpiling savings in there. We typically do not want those assets in the doctor's name alone or the physician's name alone, because if they pass away and they have significant debt, student loan debt, those assets are going to go typically to pay that debt. So we're looking at the title on your accounts, trying to maneuver things, trying to kind of do a little bit of a end run around some of the student loan companies that are very aggressive. But typically, there are a lot of ways that we can avoid, if someone dies prematurely, avoid them having to pay those claims back. So there is a way. So there's a couple questions. Do I have to share all of my assets with my lawyer in order to make a will? No. And I'll tell you that primarily when we're doing, I'll ask some preliminary questions so that I have a general frame of reference for what type of strategies I should be suggesting to you. So if I know that someone's got under $1 million in assets, my thinking and my suggestions are going to be different than if you have $1 million to $3 million or north of that. So it just kind of depends on a lot of this. I can gauge generally by knowing where you're at in the stage of your career, but you never know. And it's helpful to me, not that I need to know the nitty gritty, but it is helpful to me to have some frame of reference so that I can give you appropriate advice. If we're doing trust planning, that has to have full disclosure of what you want, at least what you want to go into the trust, because we couldn't put it into the trust without knowing what you've got and where it's located. Again, I'm not so much concerned with the value of anything unless I think it's going to be a tax problem. I'm more concerned with getting everything titled correctly, particularly if we're trying to take advantage of, getting around some creditors. What is the difference between a revocable and an irrevocable trust? So that is a really good question that we get very often, and I'm happy to answer it. A revocable trust, so revocable, R-E-V, is simply, very simply, a substitute for your will. So I'll give you an example. I had a client I spoke with today, and he wanted to make sure that he didn't have any kids, not married. He wanted to make sure that when he dies, his siblings did not get notice or a chance to object to his will. So I said to him, well, if we use a revocable trust as a substitute for your will, they don't get notice of that. We can avoid all of the notification that somebody gets legally when you're probating a will. So a revocable trust is simply a substitute for a last will and testament. Now, an irrevocable trust with the I in front of it, irrevocable, is primarily designed to avoid some kind of, or provide you with some kind of asset protection. So whether that's creditor avoidance, like student loan debt avoidance if I die, or potentially insulating my assets from the cost of long-term care, I would use an irrevocable trust in order to do that. So that's a common question, a good question for sure, and hopefully that answered it for you. Any other questions, comments, concerns? Again, you can always look for me on email. Oh, what do we have? A question coming in some other way? No. let me pop up my email here. Let me get myself out of the way. You can always email me, Anthony at themarronelawfirm.com. You can call my office, even though we're not there. We are still taking phone calls. And if you're interested, you can check out our website, www.themarronelawfirm.com. And everybody's going to be getting an email, like I said, after the webinar with a link to the slides, a link to the video, and if you want to utilize the free offer that we're hosting right now, you can certainly do that. Oh, another question. Let me answer this. So, can an irrevocable trust be modified? The simple answer is yes. Like anything else that lawyers do, there's a loophole. So even though we call it an irrevocable trust, we can still make changes to it. Not every single irrevocable trust can be changed, but as a general rule, yes, there's all kinds of loopholes. That was a good question. Okay. Well, I thank you guys for your time tonight. For those that could make it, we had a good crowd, good questions. And again, I'm Anthony Marrone, the Marrone Law Firm here in Syracuse, New York. Thank you guys, all you healthcare professionals, men and women on the front lines. Really appreciate everything you've done. If I can be of any assistance in any way, even if you just have a question, maybe you've got your own lawyer, but you just want to bounce something off me, feel free to email me. I'm happy to help. Thank you all. Have a great night.
Thank you, Anthony.